This lecture covers Chapter 6 in your textbook. Human resource management is an element critical to the successful operation of any department and any industry. Managers, directors, and supervisors who are not familiar with the basic elements of HRM serve as a potential liability for their own organization rather than an asset and are likely to find themselves embroiled in costly litigation. This lecture is intended to provide an overview of the fundamental concepts of HRM in five basic areas: recruitment, compensation, leave benefits, employer relations, termination. Success in any business requires success in competition. Companies are constantly challenged to create new and better services, programs, and benefits with which to entice the most qualified candidates to work for their organization. In the excitement of that competitive spirit, however, many managers have not been provided the opportunity to learn the basics of the recruitment process. What questions may properly be asked in an employment interview? What information should be divulged when answering a call for an employment reference? If a candidate for employment discloses the existence of a disability or need for a religious accommodation, how should you respond? Understanding the basic requirements of the recruitment process is key to creating a high-quality, stable workforce. Executive Order 11246, entitled Equal Employment Opportunity, was issued by President Lyndon Johnson on September 24, 1965. This order, generally known as affirmative action, prohibits federal contractors, subcontractors, and federally assisted construction contractors and subcontractors who conduct more than 10,000 in government business in a year from discriminating in employment decisions on the basis of race, color, religion, sex, or national origin. Certain government contractors or first-tier subcontractors with 50 or more employees and 50,000 or more in government contracts are required to develop and maintain a written affirmative action plan. In November 2000, the Office of Federal Contract Compliance Program of the Department of Labor published a rule that clarified that, except in limited circumstances, the contractor must maintain a separate plan for each of its establishments. Contrary to popular belief, affirmative action is not a quota system or a system that gives preference to certain candidates. Figure 6-1, three areas of assessment required by affirmative action. Affirmative action does not require an employer to measure and assess three areas that may be envisioned as concentric circles. Affirmative action is a commitment by the employer to proactively reach out into various employment pools and continue to seek the most qualified candidate. For example, an employer is not required to hire a member of a minority group or a female when a more qualified candidate is available. Three areas of assessment: qualified labor market, applicant pool of all qualified candidates in the employer's geographical area, applicants, pool of candidates who actually apply for employment with any particular company, current workforce, employees who are employed by the company. Employers obligated to maintain an affirmative action plan must track all applications received, including the race and gender of applicants and the position for which they have applied. Currently, This information must be tracked for all applicants as the employer defines an applicant. The recruitment process should begin with the writing of the job description. Although an employer may want or prefer candidates with a college degree for a particular position, it is important to list only those factors that are bona fide occupational qualifications. An employer may limit employment in a particular job to persons of a particular sex, religion, or national origin if the employer can show that sex, religion, or national origin is an actual qualification for performing the job. For example, let's say you need a receptionist that is fluent in Spanish because the majority of your clients are of Hispanic origin. This description is a general statement of required major duties and responsibilities performed on a regular or continuous basis. It does not exclude other duties as assigned. Part of the Fair Labor Standards Act of 1938, enforced by the EEOC, it prohibits wage discrimination between men and women working in the same establishment who are performing similar work under similar working conditions. Wage discrimination is blind to gender. A male employee may bring charges of wage discrimination just as well as a female and vice versa. One of the greatest pitfalls in recruitment is interviewing. Although human resource professionals are usually trained in current employment practices, including how to develop interviewing questionnaires or templates and what questions are not appropriate to ask, frontline supervisors and managers often do not receive this training. As a result, and with no bad intent, they may ask questions that are at best offensive and at worst unlawful. An employer has a duty to provide a reasonable accommodation for a job applicant as well as employees. Keep in mind that many states and local jurisdictions provide legal protections for members of certain classes that go beyond those provided by federal law, such as marital status or sexual orientation. Questions that may be asked during a job interview. Tell me about your educational background. What experiences led you to choose your career path? How has your previous work experience prepared you for this job? Tell me about your most significant accomplishments. What type of problems have you solved in accomplishing your work assignments? What has been your current job's biggest challenge? Describe the most common problems you encounter at your previous or current job. What happens when two priorities compete for your time? The Fair Labor Standards Act of 1938 is the federal law that defines the minimum wage, overtime, and other requirements related to how certain employees are to be paid. With few exceptions, the FLSA also requires that non-exempt employees receive wage at the rate of 1.5 times the employee's regular rate of pay for any hours worked beyond 40 hours in a one-work week. Some employees are exempt from the provisions of the FLSA and are thus termed exempt employees. Generally, these employees are classified as executive, administrative, or professional. A number of parameters must be used in determining whether any particular job should be classified as exempt or non-exempt. Because these exemptions are narrowly defined, employers should carefully check the exact terms and conditions for classification and work in conjunction with the company's human resources department and compensation experts to ensure proper classification. Improperly classifying a non-exempt employee as exempt, as well as any other violation of the FLSA, can have serious financial consequences as a result of fines or penalties imposed by the Department of Labor. These fines may be imposed against an individual supervisor as well as the company in amounts up to $10,000 in addition to civil money penalties plus damages for back pay, liquidated damages, and more. Many companies have rules that overtime must be approved in advance of being worked. What if the employee is very dedicated to the job and chooses to come in early, performs work, and tells the supervisor that the company need not pay the employee for this extra time because the employee understands that the permission was not granted in advance? Does the employer have to pay the employee for the extra time worked? What if an employee continues to work through his or her lunch period to catch up on some work? Does the employer have to pay the employee for what would otherwise be an unpaid lunch period? Even if the work is performed without the permission or knowledge of the employer, is the employee still due to appropriate compensation? May the employer, however, limit the compensation that is due under the FLSA by granting the non-exempt employee some time off later in the same work week to avoid incurring hours worked in excess of 40 in that work week? The intent of the FLSA, as drafted more than 65 years ago, was to provide compensation for an employee who performs work or remains under the employer's control. Is the employer obligated to compensate employees? Keep an eye out for the common practice of non-exempt employees who eat lunch at their desk while working. If a non-exempt employee is not relieved of his or her duties during a scheduled unpaid meal period, then the employer owes that employee compensation for the time worked, even if they are simultaneously eating lunch. In this scenario, is the employer obligated to pay that employee for that idle time? Another common practice in which many employers engage is the granting of compensatory time off from work for non-exempt employees in lieu of overtime wages. At this time, the FLSA generally prohibits private employers from granting non-exempt employees compensatory time off from work. For example, imagine that you have a research grant due this Friday. You need your laboratory assistant to work some overtime to help get some last-minute administrative details put together. When you convey this news to the employee, he says that would be fine because he would also like to take off early one day next week to take care of some personal business. If you and the employee both agree to this agreement, can you grant the employee the compensatory time off from work next week in exchange for the additional hours worked this week? The answer is no. To do so would be a violation of the FLSA. Note that legislation has been proposed for a number of years to permit this type of voluntary arrangement if the employer and employee both agree. However, those efforts have been unsuccessful. In this scenario, is the employer obligated to compensate employees for time spent parking the car? While the overall administrative oversight of leave benefits is generally regulated by Human Resources Department, problems most frequently arise at department level when a request for some form of leave is initially denied or misapplied by a manager or supervisor. For the purpose of this lecture, The leave benefits covered are presented under two categories: Family and Medical Leave Act and Military and Other Leave. Process of administrating leave under the FMLA are very broad and easily warrant another lecture by themselves. The FMLA is applicable to any employer in the private sector who is engaged in commerce or in any industry or activity affecting commerce and who has 50 or more employees each working day during at least 20 calendar weeks or more in the current or preceding calendar year. In addition, all public agencies, state and local government, and local education agencies like the schools are covered under FMLA. These employers do not need to meet the 50 employee requirement. The FMLA guarantees the employee the right to return to the same or comparable position he had when the leave commenced upon his or her return to work. A comparable position is one that provides the employee with the same wages, hours, and conditions of employment as the position originally held. The employer is permitted to run unpaid leave, such as sick leave, concurrently with FMLA. Although there is more than one definition of what conditions constitute a serious health condition, and they are quite detailed. The general definitions are those conditions that require inpatient care or continuing treatment by a health care provider. Employers have certain duties to provide some limited benefits and protections to employees who take time off from work to perform a variety of social obligations, such as those required for military service, including weekend reservists units. Separate federal laws cover nearly all employers, including federal contractors, as granted under the Uniformed Services Employment and Re-employment Rights Act. For example, Maryland law requires employers to grant employees at least 2 consecutive hours off from work while the polls are open to vote on election day. The FMLA updates that went into effect on January 16, 2009 implemented statutory amendments. It allows eligible employees to take up to 26 weeks of unpaid leave to care for a family member who was wounded while on active duty. Eligible employees are also entitled up to 12 weeks of unpaid leave for qualifying exigencies to help manage the affairs of a soldier, of the soldier's family before, during, and after deployment. The arena of employment legislation and litigation is replete with challenges to employers' practices relating to a myriad of issues under the law. Federal, state, and local administrative agencies such as the Equal Employment Opportunity Commission and its counterparts are continually challenged to meet the demands of burgeoning case loads alleging discrimination in employment based on a person's membership in a legally protected class. Title VII of the Civil Rights Act of 1964 prohibits discrimination based on race, color, creed, religion, national origin, and sex. Keep in mind that a plaintiff may file a claim of discrimination alleging discrimination under more than one federal statute as well as more than one protected class. The burden of proof in such cases rests first with the person bringing the charge to show that he belongs to a protected class, he was qualified for a job, Though qualified, some adverse employment action was taken against him, such as being fired, not hired, demoted, etc. And thereafter, the employer continued to seek applicants with the plaintiff's qualification. If the plaintiff is able to establish each of these threshold elements, the burden then shifts to the employer to show a legitimate, non-discriminatory reason for taking the adverse employment action. If the employer can do so, then the plaintiff is afforded one more opportunity to show that the reason given the employer is a pretext and not the real reason for the decision. On June 12, 2000, the Supreme Court held that the plaintiff was not required to provide any evidence that the real reason for the adverse action was based on some unlawful discriminatory intent, but only that the reason given by the employer was not true. The court held that so long as the plaintiff was able to rebut the reason the employer gave as pretextual, then it may be appropriate for a jury to infer that the employer's motive was unlawful discrimination. No issue under Title VII has received more attention over the last decade than issues related to unlawful harassment. From 1986 to 1993, the Supreme Court heard two landmark cases that laid the foundation for sexual harassment litigation under Title VII. From March 1998 to May 1998, however, the court heard three cases plus two under another federal statute that further refined the definition and liability standards for unlawful harassment. The EEOC then followed suit and published new guidelines in June 1999, stating that unlawful harassment includes behaviors based on race, color, sex, whether or not of a sexual nature, religion, national origin, protected activity, age, or disability. Thus, employers should establish anti-harassment policies and complaint procedures covering all forms of unlawful harassment. In cases in which an employee complaint alleges a personal action resulting in some tangible economic harm, such as lost job, demotion, reduction of overtime or compensation, the employer may be held liable or strictly liable, meaning the employer will have no opportunity to put forward a defense. As a result, it is imperative that employers provide and document thorough training for managers and employees on unlawful harassment prevention, multiple resources for reporting complaints, and respond promptly to any questions, concerns, or complaints related to unlawful harassment. For example, if there are two applicants for a position, one is 42 years old and the other is 52. The 52-year-old candidate may have a prima facie case of age discrimination if she can present some evidence that the employer did not hire her because she was older than the other candidate, even though the other candidate was also over 40 years old. It is important to check with your Human Resources Department or legal counsel, as many states also have laws that prohibit discrimination against persons of any age, including those less than 40 years old. The Act defines a disability as any physical or mental impairment that substantially limits a major life activity. Major life activities originally were defined as, among other things, walking, talking, maintaining active employment, and conducting daily hygiene. Effective January 1st, 2009, however, Congress amended the definition of major life activities, and it now includes major bodily functions such as functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. A common basis of the employment relationships is the at-will employment doctrine. An employee may leave his or her job anytime for any reason. Likewise, an employer may terminate the employment relationship at any time for any reason, including no reason. The limitation is that an employer may not terminate the employment relationship for an unlawful or discriminatory reason. At-will employment doctrine. Employers limit this relationship either intentionally through the use of written employment contracts or unintentionally through the creation of employment policies, practices, or statements inadvertently made during the interview process, which are later construed to create an employment contract. When it comes to terminating the employment relationship, a number of claims can arise, including invasion of privacy, breach of contract, wrongful discharge, and more. To avoid these claims, it is best to follow the 5 elements of just cause. Although they are not generally required without a collective bargaining agreement or other written contract, they serve as a reasonable foundation by which to assess the thoroughness of your reasons for discharging an employee. Forewarning. Can you show that the employee in question has received some notice, either through instruction, coaching, a policy manual, or training regarding the standard or expectation that he has failed to meet? Is this an assumption on your part, or do you have a documentation to show that the employee received such notice? Even if you believe that there is no reasonable explanation the employee could provide, it is still imperative to give the employee that opportunity to present his or her case. Evidence. Can you show that the information on which you are basing your decision to terminate is factual and not just perception or hearsay? Are there records to support your findings? If there are no tangible records, are there witnesses who are willing to give either a verbal or a written statement supporting your decision? Are these witnesses credible? For example, lateness or absenteeism may be a much more serious offense in a critical care unit, owing to the potential negative impact to patient care than it would in the Office of Volunteer Services or gift shop. Discharge is often perceived by arbitrators and courts as economic capital punishment and a measure of last resort. If it is reasonable that the employee might modify his or her behavior with a disciplinary suspension, consider that in lieu of discharge. Very serious or repeated infractions, however, deserve concomitant sanctions. Managers should also become familiar with the basics of labor law and employees' rights under the National Labor Relations Act. This prohibition against reprisal arises under the same laws that prohibit discrimination on any basis, including race, religion, gender, age, and disability. Particularly under Title VII, there is a broad definition of the kinds of personal actions which are considered retaliatory. The Supreme Court has recently held that retaliation can take the form not only of suspension, demotion, or termination, but can be any action by the employer that is likely to deter another individual from claiming or participating in a proceeding involving discrimination. Such actions can include less attractive assignments, involuntary shift changes, and similar actions. Managers or supervisors naturally may be angered and disappointed to learn that he or she has been accused of discrimination. Nevertheless, these officials must be trained to accept such accusations as part of the job and to avoid treating the complaining employees differently because of the charges. At the same time, employees cannot expect to use the prohibition of reprisal as a shield to engage in conduct that is otherwise subject to discipline. One of the most challenging areas of management are those involving human resource guidelines and regulations. The employment relationship can be as rewarding as it is fraught with pitfalls for liability. It has been the goal of this lecture to provide clinical laboratory managers and supervisors with some of the basics of the employment relationship so they may proactively identify issues in the workplace that have the potential to disrupt business operations and begin generating alternatives for avoiding a problem rather than trying to negotiate the settlement of a problem after it has arisen. The best manager and administrator need not be an expert in any of these areas but should be familiar with the basic concepts.